Assalamualaikum warahmatullahi wabarakatuh. We are from Group 2 of Family Law subject. Would like to present our assignment on the first question, which is analyze the position of the welfare principle as a paramount consideration in children's custody cases when divorce happen. Without further ado, I, as the first presenter, I'd like to introduce myself first. My name is Siti Nur Afifah Humaira binti Abdul Muttalib. My matric number is 0646 and 55. Today, I will begin our present with introduction. According to the general provision in the Child Welfare Act, Article 1, subsection 1 states that all citizens shall endeavour to ensure that children are born and brought up in good mental and physical health. The Article 1, subsection 2 also stated that all children shall equally be afforded the guaranteed level of life and be kindly treated. In Article 2, the national and local governments shall be responsible for bringing up children in good mental and physical health, along with their guardians. Meanwhile, in Article 3 stated that the provisions of the preceding two articles constitute the basic philosophy to guarantee children's welfare, and this philosophy shall be consistently respected in enforcing all laws and regulation on children. Child welfare is a continuum of service designed to ensure that children are safe and that families have the necessary support to care for their children successfully. Child welfare obviously established to support or coordinate service to prevent child abuse and neglect. It is also to provide service to families that need help protecting and caring for their children. Child welfare also receive and investigate reports of possible child abuse and neglect, assess child and family needs, strength, and resources. Other than that, there are also arrangements for children to live with kin, i.e. relatives, or with foster families when safety cannot be ensured at home. It supports the well-being of children living with relatives or foster families, including ensuring that their educational needs are addressed. The Child Welfare Agency works with the children, youth, and families to achieve family reunification, adoption, or other permanent family connections for children and youth living foster care. Each state or locality has a public child welfare agency responsible for receiving and investigating reports of child abuse and neglect and assessing child and family needs. However, the child welfare system is not a single entity. Public child welfare agencies often collaborate with private child welfare agencies, community-based organizations, and other public agencies to ensure that families receive the service they need, such as supportive child care, parenting classes, in-home family preservation service, mental health service, and substance abuse treatment. In Article 4, subsection 1, the term child is used in this act shall mean a person under 18 years of age. Children shall be classified into the three categories, which are firstly, infant, who is a person under 1 year of age. Secondly, a toddler, who is a person of 1 year of age or more before the time of commencement of elementary school. Lastly, juvenile, a person who is under 18 years of age after the time of commencement of elementary school.
Assalamualaikum. My name is Nur Afzal binti Muhammad Fakurazi. My matric number is 06410 and I'm in charge for the part of the application of welfare. The foundation of all child legislation is welfare, who may make no decision impacting a child's upbringing without considering the child welfare, albeit the exact weight to be given to the idea differs depending on the circumstances surrounding the legal issue. According to Section 1, Subsection 1 of the Children Act of 1989 states the following principle. The first one is anytime a court rules on a matter involving. Second one, a child upbringing and the third one, the child welfare shall be the court top priority when deciding how to administer the child property or use any money resulting from it. The Children and Families Act of 2014 adds a new subsection 2A that instructs court to presume, absent evidence to the contrary, that a parent's involvement in the child life will advance the welfare of the child when deciding whether to issue Section 8 order, a parental responsibility order. Below, we will look at this reform. As modified, the Guardianship of Minor Act 1971 established the child welfare as the only one factor. And this has been the case ever since J versus C 1970 AC 668. The majority of child law exists in the form of statutes. Wardship and inherent jurisdiction are the other two jurisdictions that can settle dispute involving children. The jurisdiction is wardship dates back to the medieval era and parents patriae. Mason et al. P. 6 to 3, even though it's frequently said that the court used its inherent authority in wardship. Modifications are made. According to the Children Act of 1989, there is a separate inherent jurisdiction from wardship with roots in the parents' patria jurisdiction. These jurisdiction have been made of less practical importance since the Children Act of 1989, but it is nevertheless vital to give a quick review of them.
Assalamualaikum, and my name is Nudini Soleha binti Muhammad Effendi. And today I'm going to talk about what is the legal consideration to consider in child custody. In the context of guardianship, the legal and practical connection between a parent or guardian and the child in their care is referred to as child custody. Legal custody is the authority to make choices about the kid, and physical custody is the obligation to keep the child in a home, provide for their needs, and take care of them, are both parts of child custody. Children of married parents typically enjoy shared legal and physical custody. Typically, decisions about child custody come up during divorce, annulment, separation, adoption, or parental death processes. The best interests of the child standard are used to decide child custody in the majority of jurisdictions. Legal custody entails the allocation of decision-making authority over their minor children between the parents. These choices could relate to a child school, doctor, medical, procedures, recess, counseling, and psychotherapy, and religion. Legal custody can be single or joint, meaning that just one parent has the authority to make important decisions without taking into account the other parent's preferences. First, conditions of custody and right of person given custody. According to Section 89, Subsection 1 of the Law Reform Act, the custody order may be established subject to any conditions the court may see appropriate to impose, and the person granted custody shall have the right to make all decisions regarding the child's upbringing and education. This clause grants the right to make decisions regarding the kid's upbringing and education to the individual who has been granted custody of the child. Next, visitation or access rights. In accordance with Section 89, Subsection 2, G, Law Reform Act, the order may also grant the parent who has been denied custody the right to see the kid or let the child to visit a parent. In accordance with Rule 76, Subsection 2 of the Divorce and Matrimonial Proceedings Rules 1980, the petitioner or respondent must apply to the registrar for access to a child, and if the other party agrees, the registrar can decide how much contact will be granted. This is the parent of the child who did not have custody of the child's visitation or access rights. Number 3 is custody to be decided at the time of divorce or judicial separation. According to Section 90, Subsection 1 of the Law Reform Act, one of the issues the court must resolve during the divorce or judicial separation is who will have custody of the children. In the acknowledgement of service of the petition in Form 6 of the Rules 1980, the respondent must specify whether he wants to contest the custody of the children. Either the mother or the father of the kid may request a court order stating which parent is unfit to have custody of the child. As a result, the unfit parent will no longer be eligible for custody of the kid. On the application of an interested party, the court may nevertheless modify or annul the custody order. The court can also alter the conditions of the child custody agreement if it is reasonable and in the kid's best interest. When the child reaches the age of 18, the custody order will be null and void. Law Reform Act, Section 95. Number 4 is the order of custody may prohibit the person given the custody from taking the child out of Malaysia. This is applied where the matrimonial proceeding is pending or when one parent has custody of the child to the exclusion of other. The court can issue an injunction restraining the other parent from taking the child out of Malaysia as provided in Section 101, Subsection 1 of Law Reform Act. This is also provided by Rule 77 of the Rules 1980. Lastly, is reference to welfare officer. The court shall take the advice of some person who is trained or experienced in child welfare when considering questions relating to custody. However, the court is not bound to follow the advice given by these welfare officers. Section 100 of Law Reform Act, Rule 78 of the Rules 1980 provides the same.
Assalamualaikum warahmatullahi wabarakatuh. My name is Isabrina Osman binti Azizan. My matric number is 065144. And for this assignment, I will talk about whether child custody only awarded to one parent. No, joint custody is a type of child custody in which both parents share custody rights. Joint custody can refer to either joint physical or legal custody. The child spends an equal or nearly equal amount of time with both parents when they have joint physical custody, also known as shared parenting or shared residency. Joint custody, however, is defined is built on two pillars, sharing and cooperation. The joint custody arrangement allows for close relationship between parents and the child and frequent access for all. The rationale for joint custody is that children benefit from continued and regular contact with both parents and that both parents play an essential role in child rearing. In general, joint parenting benefits the child. The joint custody order reminds divorced parents that the law expects both to cooperate and promote the child's best interests. Custodial charges of this type encourage the non-custodial parent to continue performing the parental role, reducing the likelihood of the non-custodial parent being excluded from the child's life. Joint parenting in a collaborative setting is always beneficial to the child. In several recent rulings, the court have recognized the paramount importance of joint parenting. In the case of Tan Sherry versus So Shen Fight, 1264, the respondent agreed that the child would be placed in the care and control of the petitioner and that the child would be brought to live with the petitioner in Singapore, where the petitioner works, and that the child would be enrolled in a Singapore school. The parties had also agreed that the respondent would have reasonable access to the child and visitation rights on the third weekend of each month. The petitioner was adamant about obtaining sole legal custody of the child, which the respondent refused. The respondent desired joint legal custody to retain his right to have a say in the child's education and future while allowing the petitioner to care and control the child. Both the petitioner and the respondent testified. After reviewing the facts and the law, I determined that while the parties had agreed that the petitioner would have care and control of the child, both the petitioner and the respondent should have joint legal custody of the child. As a general rule, child rearing in a family must be a joint cooperative endeavor of the parents. Even if the marriage fails, instead of being at odds as husband and wife, both should put aside their differences to decide what is best for the child jointly. This would entail them communicating civilly and courteously with each other for their child's upbringing and development. The petitioner said that the evidence indicates that the respondent is rational and reasonable and willing to make decisions in collaborating with the petitioner for the child's benefit. As a result, I see no reason to deprive the respondent of his fatherly duties to the child and to allow the child to feel attached to both parents.
Assalamualaikum. My name is Nur Aisha Umairah binti Muhammad Asri. My matric number is 061987 and I will talk about the legal origins of child welfare and is child welfare is totally determined by the interest of the child. Legal origins of child welfare. Child welfare is an evolution when the child welfare system has evolved throughout the history of the United States. It is based on the changing beliefs and the attitudes about the role that the government should play. Early government efforts to assist children in need were modified by the practical worries about providing for their physical requirements, then worrying about the detrimental effects of abuse and neglect on children's development. When did child abuse become a public concern? It started from the case of Mary Ellen Wilson of New York City, when the Society of the Prevention of Cruelty to Animals, SPCA, stepped in to save her from her vicious foster parents. In the United States, poverty programs have been mostly developed with children in mind. The strong free market individualism that has been continually mobilized to oppose public assistance to needy children had to be overcome in order to show sympathy for impoverished and mistreated youngsters. The diagnosis of poverty as a result of personal immorality and even its legalization as a form of punishment for immorality have frequently been made, and as a result, poverty has been excluded from the discussion of public policy. Although many of these kids had at least one living parent, almost always a mother who was unable to support them, many of them were not orphans in the modern sense of the word. The kids were often placed in the custody of relatives with help from the neighborhood overseers of the poor when they were small. Older ones were indentured to other families to work. Children from wealthy families were frequently indentured in this fashion to learn a trade from adults who would, it was thought, be less indulgent than parents. Is welfare custody totally determined by the interests of the child? It is generally known that the well-being of the kid in question will always be the first and most important factor taken into account by the court when deciding whether to grant a custody request. The conduct of the parties, their financial and social standing, the sex and age of the child, his wishes to the extent that they can be ascertained given his age, the confidential reports that a social welfare officer may present, and whether in the long run it will be the greater interest, welfare and happiness of the child are all necessary considerations when deciding whether the welfare of an infant is of the utmost importance. However, the welfare of the child is always of the utmost significance. The care, comfort, attention, well-being and happiness of the kid are things that should be taken into account while determining the primary concern. first case related to this is K. Shantakumari versus Vijayan, and the second is Laura Doris Lawrence versus Turaisingam James. The court ruled that it should take into account the child's welfare from a variety of perspectives, including physical, mental, moral, and the child's anticipated future. The child's age, gender, and religion should also be taken into account, as well as the parents' background, race, culture, and behavior, as well as the traditions the child has grown up with. The maintenance of a stable and secure family where the children can experience love and affection seems to be the most significant element that should be taken into account. For the case, Tang Eun Kim versus Yu Peng Xiong.
Assalamualaikum warahmatullahi wabarakatuh. I am Nur Alizati binti Hamizi and my metric number is 062030, and I will talk about the conclusion. When some couples want a divorce, the couple may have disagreements about many things about their rights that they can or want to get from the marriage, and things will get harder and messier when children are involved in the divorce proceedings. Child custody is not just about being fair to the couple, but the child welfare has to be considered and fair to the child too. The welfare principle can ensure that children are not exploited for the interest of adults. Welfare principle is important to make sure that the children have a good life and can avoid themselves from getting into hard situations in the family, like physical or mental abuse by whoever gets the child custody. The child's interest can be well managed by a right person, so the child welfare is protected and can be used for the child needs. The child's interest can be well managed by a right person, so the child welfare is protected and can be used for the child needs. The child will not get stressed if they have a guardian or someone who get the child custody and who is truly take care of them well. The welfare of the child must come before and take priority over any other factors, and the paramount consideration in child custody in Malaysia shall always be the welfare of the child. Thank you. That's all from us.